my thought. I thought about the question. I brought up the problem questions, like everything.
It's
of
your
course,
creation,
I've been
but
there's the supervisor helping here and there, but ideally,
it's difficult to say you own monopoly over, because they could happen to anyone, and anyone could experience it.
my mother is shouting at me, and I'm the same person, right? And then someone else comes and does the exact same thing. I can't say it's my idea that I came up with. Hello and welcome to the Sisters-in-Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. On this podcast, we discuss matters law.
From talking about family law to property law, tax law, contracts law, we've got you covered.
Remember to like, share, subscribe, and leave a comment down below.
So we're back again with Miss Emma,
our expert on intellectual property.
Yeah, and there is a lot to learn. I mean, it can't even fit in one episode. That's why we're giving it to you in parts. So on this episode, we want to talk about copyright specifically, and specifically in light of content creation. Yeah, so we mentioned in the last episode that copyrights would generally cover things like scripts, right? Yeah.
Music,
software, music, content creation,
books,
yeah, literally artistic things,
works,
right?
Yes.
Yeah, a song, a poem, yeah, photographs. Wow, photographs.
Oh, photographs.
Yeah, actually, photographs. There's a time I wanted to use someone's photo on my website, and then she went like, "Oh, this is." There's someone who's actually her.
Oh,
yeah. So. Yeah. Anyway, yeah. So, copyrights. Tell us about it. Yeah.
So like you've had, copyright is quite vast, and most of IP work might fall here. So you might also fall under copyright if you are a content creator, if you're a musician, if you are a scriptwriter or a movie producer, this is where you might fall under. But copyright is the exclusive right given to the owner of copyright to use, distribute, alter, and give permission to anyone else to deal with that thing in any way. So if someone has a copyright to something, or if something is subject to copyright by someone else, you can't pick it and use it without getting the permission of that person. So that means even for you, if you have a work of copyright and someone else uses it without your permission, you can stand on your 2 feet and tell them to stop. Yeah. Copyright now covers, Bev has mentioned, literary works. So books, poetry, what else? Scripts, if you have scripts, anything really that's written, but it can't be like one line, like something long that has been written down. If you have slides that you use for training, for example, that would qualify there. There's also software. If you've come up with a software, then you can protect it as a work of copyright, because principally software is codes that have been written down that when you input somewhere, it's gonna work, right? So those particular codes that you're using to power the software, you can protect under copyright. We've talked about music. For music, there is copyright and there's also related, or what are sometimes called neighboring rights. And it's because when you hear a song, there's usually words underlying, yeah? There is a melody underlying. Those things, we presume they were, at some point, someone wrote them down and then decided, I'm going to go and record this thing. So that underlying work is subject to copyright, then the things that that enable it to be heard, to turn into a song that we can hear on a streaming platform, those are now what are called neighboring rights. We'll talk about that at a later time when there is time. There's also photographs. We mentioned photographs and audiovisual works. So videos and photographs would fall under copyright as well. If you are a content creator, I'm sure you'll have a video or two. Consider protecting them under copyright. Finally, broadcasts. Broadcasts are what you see on TV, like a news broadcast, a live broadcast. If you go live somewhere, that thing that you broadcast, that is a work of copyright.
Why sometimes when, let's say for example, there's a TV station that cannot access a certain live footage, when they play it on their own channel, they usually have to write the name of the actual courtesy of, okay.
Yeah, that footage belongs to the person who streamed it, who broadcast it.
Yeah.
Okay. Okay. Wow. So the news that Citizen gives belongs to Citizen.
Yeah.
And the ones that KTN gives belongs to KTN.
Yeah.
Okay.
Yeah. So as a content creator, how do I not get into trouble? Because you can get into trouble, right? You can use something that you're not supposed to use. Or should we talk about first of all how to protect your creation as a content creator, and then you tell us how not to get into trouble with, let's say,
Using
for example,
other
using
people's
other people's
creations.
creations.
Yes.
Yeah.
So how to protect your work. I'll talk about how to protect copyright generally, whether you're a content creator or not. If you have assessed yourself and you see this is where I fall and I might be a copyright owner, then it's important to register. Now, first I'll mention intellectual property as a whole, and copyright does not protect ideas. You can say, I had an idea for a painting, then that person painted the painting of a girl on a swing, they stole my idea. That won't fly. What intellectual property protects is the expression of that idea. If you had the idea of a girl on a swing, and then you actually painted it yourself or sketched it, and then Beverly came and saw it, and then she decided to do something similar to that, then you can argue that they stole something. I hope that makes sense. If it's an idea, it's still in your head. It could turn into anything. At any point, it could transform. And we can't, us from outside looking in, how can we verify what the idea looked like in your head?
But just a quick question. If, as you said, Bev had already drawn something and then you came and wanted to like maybe make it, maybe improve on it or something, but the idea is hers, what if she had not protected it?
Copyright protection exists automatically once you express your idea in a tangible form. So, for example, yeah, registration is not mandatory, and I will explain. Once you express it in a tangible form, it enjoys copyright protection automatically, so long as it is original. You see, so that's why if I saw Bev's thing and then I copied it, doesn't mean I enjoy copyright protection automatically if it wasn't original. First, it has to be original. Second, it has to be fixated in a tangible form, so on a piece of paper, on a voice note, on a photograph, like you took a photo of something, you see. But it's now outside of your head, it's in a tangible form, it's fixated in a tangible form. Kenya doesn't require that you mandatorily register your copyright. However, we advise it because it makes it easier to prove your case if you're claiming that it belongs to you. In other countries, in some countries, you don't get to enforce your rights, especially in a court of law, if you don't have a certificate for the thing you're claiming to own. So just register, it's a pretty simple process. It's done by the Kenya Copyright Board. Just go to the Kenya Copyright Board. Yeah, Kenya Copyright Board website. You'll see what is called the National Rights Registry. Follow the steps, and it's quite user friendly. You can follow the steps until you're done. Pay if there is any payment that needs to be made, and then you have your certificate.
So also, I had a question on how do you get permission? How do you prove? So if I have registered a copyright, like on my music, for example, so would you come to me verbally or should you get like a letter, or am I licensing it to you? Like how do we prove that you got permission from me? I don't know if that makes sense. Yeah.
So a permission is a license. So however you call it, it's still permission. Like the underlying thing is, I'm giving you permission to do this and don't do that. So however you get it is okay so long as it exists. I strongly advise, it's okay. I strongly advise that you get it written down, because then it's easy to prove. Because if you, and then it's very easy for us to be talking, then something is misconstrued. But at the point that we've sat down to write it down, our thoughts have to be very clear. Yeah. So I would advise that you write it down, reach out to the person whose thing you want to use and say, I would like to use this thing for this and this and this. Can we agree? Can you grant me permission? Akisema well and good, then you can proceed.
So therefore, does it mean that if I have sought permission from you, I have to pay, or there must be no consideration whatsoever? One, and then also, if I have not registered it, how do you seek for permission from me? How do you receive a license, for example, for me and it's unregistered?
Good question.
I will start with that question because, like we've said, in Kenya, registration is not mandatory. Registration for copyright is not mandatory. The moment that the thing exists is fixated in a tangible form, you already enjoy copyright protection. So even if it's not registered, it's not leeway for you to just use it because that person didn't register. They still own the right to the thing that they created. And your other question was how licensing. So even if you still have to get a license, even if they don't have a registration certificate, you still have to get a license.
I have 3 very dicey questions. And they're burning. I think it's about getting into trouble as a content creator. Number one, I'll use examples. The first one, there's this, let's say, for example, there's a certain content creation style. A comedian, right? The first person who started it is, let's say, person X. Let's say, for example, there's this common thing that people do in Kenya whereby you imitate your mother and things like that, mama, whoever, right? A lot of people are doing it now, but there was the very first person who started doing it. Can this person sue if the other people copy? That it's an idea, right? And it has been expressed.
So if the expression of that idea is exactly the same as yours, then that's different. That becomes a problem. And my question is, how many sitcoms exist? For example, there was the first person to ever think, oh, actually, we could do a show where people are sat, we do a comedy, then there's a studio audience laughing, or there's a laugh track. You see, the style in itself is unique, but if the expression is exactly the same, if the characters in Aquila's sitcom are exactly the same as yours, you see, they say the exact similar things, then it becomes a problem. However, if we're imitating our mothers, all of us have mothers, right?
So what if, let's say, for example, I'm a man?
It's difficult to say you own monopoly over, because they could happen to anyone, and anyone could experience it and then decide to express it in a similar way.
Really?
Yeah.
So it's not my idea if, let's say, I'm a man and I've decided to dress like my mother, and then the next scene I am myself and my mother is shouting at me, and I'm the same person, right? And then someone else comes and does the exact same thing. I can't say it's my idea that I came up with.
If they use the exact same words, maybe I'll say hapo kuna shida. But the way you've said, it's kind of difficult to say, to clearly say that this thing belongs only to, especially when it's to do with a style. It's difficult because under copyright, things like concepts, those are usually not protected. Formulas, those are usually not protected because they could happen to most people. For personalities, it's difficult to say that you can get copyright with that person.
So that copyright does not stand really, or can you just register it?
In the person, no. Unless your character has a unique name. For example, I'm not very creative, so I can't come up with an example. But if they have a very unique name, you can get a trademark, and then that means me, when I come to do my own teacher skit that's similar to yours, I can't use the same name as you. So that kind of gives you some sort of monopoly. However, the style itself, we could argue that it's people. People will speak. Yeah, your teacher will likely speak, and it's possible both of us were in the same class and we had the same teacher, and we both drew inspiration from the same teacher.
So now, ideally, you can protect the script and the video.
Okay.
But not the person and the character.
The person, the character, I will say a little bit about the character because there are instances where a character can be protected. So understand in animations, for example, Mickey Mouse, and that's because it's a unique character because it's been drawn out. So there's the way that that particular character will look like. For animations, you decide this is how they're gonna walk, this is how they're gonna dress. Such characters can be protected. Yeah.
So if I start my own Wakurugezi show, and I just call it something different, no one will come after me.
If it's unless it's play by play, you use the same words, it's gonna be very difficult. If we can think about talk shows, how many talk shows exist and they have similar, if we can think about the US alone, there's the Daily Show, Jimmy Kimmel Show, there's many that exist. So if it's not something that's absolutely unique, then it's gonna be quite difficult to say that that thing is protected and unique to you alone. Yeah.
So my second question is TikTok videos. Let's say, for example, the way there's usually like an audio of someone else talking, and I come and just lip sync. Yeah, the words are not mine, but if you read my lips, it's just the same thing that the person who recorded it earlier is saying. Can this person who owns that audio come and claim that you owe me that's my sound? Number one, it's they're my words. The only thing you're doing is syncing your lips to them.
Okay. So that brings me to thing number 2 on how to stay out of trouble if you can. Terms and conditions. Every website has terms and conditions, community guidelines, policies, data protection policies, privacy policies, all those things. They're the things that guide on what you can do and what you cannot do. For some apps, especially user entertainment, you'll find that there's a remix option. So you're doing something but the audio is from someone else and the app has allowed it. So that means you as well, as you are uploading it, you allowed that other people can use it in that sense, and that's how come people are able to use your sound and sync it to their own videos. So always confirm the terms and conditions. Are you allowed to do so? And if you find the video that you're looking for or the audio that you want to synchronize to your video is not there, ask the person if you can use it. Because if they didn't give that permission to the app, there's a possibility Hataki to make it in that sense. So if they don't want it to be used in that sense, get the permission that you are talking about.
That's, for example, maybe if you're doing a reel and you want an audio to accompany that reel.
Yeah, and that audio isn't available in the app. Okay. You've checked the app and it's not there. The voiceover you want is not there, but you know where to find it. So talk to the owner of that voiceover, talk to the owner of that song, talk to the owner of that music, whatever it may be. Let them give you permission, and then now you can synchronize it before you post. Okay. Yeah. And my third question. Yeah, I'm glad I answered you then. But I was gonna say the third thing that I'd say to protect yourself, to think about as you protect yourself if you're a content creator. These are not all of them, but just think about these and others. Using people's logos. If you are in a video and then you have someone's logo, have they agreed to have that logo there? Are they happy with you putting their logo in your video? So always confirm, because again, trademarks give you monopoly over that mark. So if someone is using it and you have a trademark and someone is using it, you have a right to go tell them stop. In a similar way, whoever owns that trademark can come and tell you to stop. Yes, that includes sound bites, slogans, all of those. So just consider it um, and get permission from those people. And then finally, defamation. Just be careful with what you say. Because if you say things that are not untrue and someone feels like their reputation has been hurt because of what you said, you could get in trouble. So just don't be very careful with what you say. Make sure it is fact checked. Don't say things that could get you in trouble and you have not verified them, or you do not have a way of verifying if they are true.
So even as we round up, can somebody lose their copyright? Like what would make you, if I have registered a song, I have gone and gotten like a copyright for this specific song, what would make me lose these specific rights other than the time lapsing and yeah.
Okay. So unless you produce work and say you want it to be for the public domain, then copyright remains with you. Whether here in Kenya, whether or not you have a registration certificate, you have the copyright. Copyright will lapse if it's for literary works, and so that scripts, books, and all that. It will lapse 50 years after the day that the author died, after the end of the year when the author died. So assuming you wrote it this year, or rather you wrote it and then you passed on this year, will count 50 years after. From 2026, we start to count 50 years. After that, it enters what is called the public domain. So that means anyone can use it without having to seek for permission. Otherwise, if something was original to you, you don't lose the copyright unless you decide to give it up and say, I want this work to be available for the public domain.
I have seen contracts whereby, for example, if you're working for a certain company, there's a clause that sometimes can say, while you're working for us, anything that you produce, any copyrights, any trademarks, or whatever, belong to this company.
Yeah, like even like writing our thesis in school.
Yeah,
you say it belongs to the school. What do you mean?
Yeah.
So now, yeah.
But they say now,
Copyright gives you an exclusive right.
but now they say that you can just be, how is it called, footnote?
Yeah,
like you can be footnoted, but the permission can only be sought from the school.
From the school.
Yes.
It belongs to the school now. Or maybe let's say
But
it's a production company and you, I don't know, did the song. Sometimes they can put it in the contracts, right? It belongs to the company. I mean, contracts, there's always freedom of contract and you can give away such things without your knowledge.
But that is actually a copyright principle. Okay. Yes, we've said that there's an exclusive right with copyright. The exception to that rule is if it was a work made for hire. So that means I hired you specifically to write a movie for me, or to take photographs for me, or to shoot something for me. I hired you specifically for that purpose. That work belongs to whoever hired you. Number two, work done while you are in school. That work belongs to the academic institution.
Why? You see, wait, we could argue that this is my thought. I thought about the question. I brought up the problem questions, like everything.
It's
of
your
course,
creation,
I've been
but
there's the supervisor helping here and there, but ideally or originally, the idea belongs to me.
the song is mine.
Yes.
However, if for 4 years or whatever number of years you were in that school, the school didn't make sure that there were teachers to teach you, you wouldn't have gotten to the point
But the
of
idea.
forming the thoughts.
Okay.
So
Or if
it
they
belongs
wouldn't,
to the school.
yeah, or if they wouldn't have given you an appropriate
school.
environment to come up with your song.
Research material.
Yeah.
All those things.
Okay. Yeah.
So that's-
Research material. Yeah.
That's sort of the justification, but it belongs to the school. Work that is created under employment, it belongs to your employer. Sawa. Yes. So next time, if you're in school, again, like you said, contracts you can negotiate. If you're creating something and you know this thing, I would like to go home with it before you finish, go and talk to the dean of your institution. Go talk to someone, ask them, I have an idea to do something. Can we discuss what's going to happen with the IP and the revenue that will come out of that IP?
Especially with music, yeah, because you can get a lot of money out of it, and then you just signed something, and you let out. I mean, you gave away your rights to someone else.
Because also, like if you do a thesis, it could be a chapter of a book, and the book would be distributed. You get, so you're going to be a sort of an author in that book.
You will be an author, and you bring up an important point because just to wrap it up, we've said in the previous episode, I think we asked what does the intellectual property space actually give the owner of intellectual property. And for copyright, it gives you two major sets of rights. There's an economic right and there's a moral right. Economic right means we need to make money. When this thing makes money, let's make it together. And the moral right means you will be footnoted, you will be credited for the work that you did. The moral rights are not transferable. Even if the thing you created belongs to your employer, to the person who hired you, to your school, you have to be credited for the work that you created. So that at least when I go read the chapter and I see that it was Beverly or Aquila that wrote this part, I can trust the work you did and say, okay, let me go back to them. Let them write for me a similar thing. Yeah. So there is a moral right and there's an economic right that comes with copyright.
Okay, it's a lot. It is a lot. Yeah. And because we don't want to go
For so long.
overboard and have like a very long episode, we're just gonna end it here. And then we'll talk about more things in the next and in the next and in the next, because I think this is it's an emerging area. People are becoming more aware of their rights, their intellectual property rights. And yeah. Anyway, thank you for watching. I am sure you have learned a lot, as have we.
Yeah, we have learned a lot.
Yeah. See you next time. Thank you for watching. Comment down below. And bye. See ya.
My thought. I thought about the question. I brought up the problem questions. Like everything.
It's your creation.
I've been there's the supervisor helping here and there, but ideally,
it's difficult to say you own monopoly over because they could happen to anyone. And anyone could experience it.
My mother is shouting at me, and I'm the same person, right? And then someone else comes and does the exact same thing. I can't say it's my idea that I came up with.